Hello everyone and welcome back to my channel, OnD-mand, where I, Aaron, will be sharing some experiences with you as an Illinois notary. I take no credit and give God all the glory for the information that I'm about to share with you today. Welcome if you are new. This is episode 3. We will be breaking down the entire Illinois Jesse White handbook. I am so excited. This week we go into forms. We go into just a lot of good information. Bring it up on your cell phones, laptops, tablets. If you have a paper copy, bring it up so that we can go through it together. I just want to say thank you to all of you. I appreciate all of you for allowing me to work with you. Each video in this series, like and share so that other notaries can be abreast of this free information. All right, let's get into the video. All right, so we are actually going to continue. We are on page 13, Article 4, change of name or move from county. Okay, and this is starting off 4-101. Changes causing commission to cease to be in effect. When any notary public legally changes his or her name or moves from the county in which he or she was commissioned, or if the notary public is a resident of a state around Illinois. Don't forget, in the first episode, I did list all of those states that in which Illinois does accept commissions if you do not live in Illinois. No longer maintains a principal place of work or principal place of a business in the same county in Illinois in which he or she was commissioned. The commission ceases to be in effect and should be returned to the Secretary of State. So if you are commissioned in one county, your residence has to be that same county, and you will be able to provide Notorious Acts throughout all 102 counties within the state of Illinois. As you can see, Article 4, if your commission and your residence is not the same and you don't take that time out to change that, of course, they do give you a period to change that. Not only can you not be a notary in your county, but throughout the whole state of Illinois. These individuals who desire to again become a notary public must file a new application, bond, and oath with the Secretary of State. You do not want to go through this all over again. So if you move or change your name, change the county. Continuing Article 5, reappointment as a notary public. 5-101, reappointment. No person is automatically reappointed as a notary public. At least 60 days prior to the expiration of a commission, the Secretary of State shall mail notice of the expiration date to the holder of a commission. Every notary public who is an applicant for reappointment shall comply with the provisions according to Article 2 in this act. So just go back to my previous videos and within your own handbook that you have in your hand, go back and read Article 2, and here's your source. Section 5-102, solicitation to purchase bond. No person shall solicit any notary public and offer to provide a surety bond more than 60 days in advance of the expiration date of the notary public's commission, nor shall any person solicit any applicant for a commission or reappointment thereof and offer to provide a surety bond for the Notary Commission unless any such solicitation specifically sets forth in bold-faced type, not less than 1/4 inch in height, the following. We are not associated with any state or legal governmental agency. Whenever it shall appear to the Secretary of State that any person is engaged or is about to engage in any acts or practices which constitute or will constitute a violation of the provisions of this section, the Secretary of State may, in his discretion, through the Attorney General, apply for an injunction, and upon a proper showing, any circuit court shall have power to issue permanent or temporary injunction or restraining order without bond to enforce the provisions of this act. You don't want to get in trouble. And either party to which suit shall have the right to persecute and appeal from the order or judgment of the court. Any person, association, corporation, or others who violate the provisions of this section shall be guilty of a business offense. Remember, we talked about business offenses, the second video in the series, and punishable by a fine of not less than 500 for each offense. 6, Notorious Acts and Forms. We're getting into the good part. All of it is good part. All of it is law, but I know a lot of questions come from the rest of this handbook. Section 6-101, definitions. So these are definitions. A, Notorious Act means any act that a notary public of this state is authorized to perform and includes taking an acknowledgement, administering an oath or affirmation, taking a verification upon oath or affirmation, and witnessing or attesting a signature. Notice in A, Notorious Acts, it says to perform and includes. So that's just a cusp. That includes. Okay, so that's not everything. B, acknowledgement means a declaration by a person that a person has executed an instrument for the purposes stated therein, and if the instrument is. So just before we continue to page 14, right here it says acknowledgement means a declaration by a person that the person has executed an instrument for the purposes stated therein. Therein meaning whatever is in that instrument, whatever is in that document. So let's continue. Executed in representative capacity. So let's go back here. Okay, if the instrument is executed in a representative capacity, that the person signed the instrument with proper authority and executed it as the act of the person or entity represented and identified therein. So right here in B, as you can see, representative capacity, which gives a hint as to what capacities a notary can act in. Let's continue. C, verification upon oath or affirmation means a declaration that a statement is true made by a person upon oath or affirmation. D, a representative capacity means for and on behalf of a corporation, partnership, trust, or other entity as an authorized officer, agent, partner, trustee, or other representative. Let's continue. As a public officer, personal representative, guardian, or other representative in the capacity cited in the instrument. as an attorney in fact or a principal, or in any other capacity as an authorized representative of another. So I've heard someone tell me that there is this notary group. They are on Facebook telling Illinois notaries that they cannot do notary presentment in Illinois. Well, according to this law, yes, we can. You see that the head is rolling like that, which means yes, we can. Look right here. I'm telling you, there's so much more to being a notary than stamping your seal. There's so much. Look at what it's saying. D, in a representative capacity. That is specifically why when I define notary presentment, I've upon doing so much and really just seeing what it does and reading this law, I've come up with the meaning for notary presentment to be acting within a representative capacity on behalf of his or her client as a third person public officer of the court, officer of the circuit court, between a client and a respondent because a payment is due. So there is so much you can do. Obviously, look at what it's saying. This is so big right now. I hope everyone can really grab this right now. As a public officer, personal representative, guardian, or other representative in the capacity cited in the instrument. That is so big. If you have any questions about this, please leave it in the comment section. Let's continue, because this whole upper portion, I could stay on that upper portion for another video. Let's continue. And if you have not watched my video on notary presentment, please do so. I'm going to put it in a card above so that you can, and I'll also put it in the description box below so that you can go and watch that. Section 6-102, Notorious Acts. A. In taking an acknowledgement, the notary public must determine either from personal knowledge or from satisfactory evidence that the person appearing before the notary is making the acknowledgement, and making the acknowledgement is the person whose true signature is on the instrument. Now notice what it says. I hope you guys caught on to that. A, let's read that again. In taking an acknowledgement, the notary public must determine either from personal knowledge. I can say, if I've known a person, if my friend, if I am doing a notarial act for a friend of mine, I don't have to look at her ID. I don't. Why? Because I am acknowledging her by personal knowledge. That is law. It's right here. Oh, I know you. I don't need your ID. You see how big my eyes are? Let's continue. B. In taking a verification upon oath or affirmation, the notary public must determine either from personal knowledge or from satisfactory evidence that the person appearing before the notary and making the verification is the person whose true signature is on the statement verified. In a witnessing or attesting a signature, a notary public must determine either from personal knowledge or from satisfactory evidence that the signature is that of the person appearing before the notary and named therein. A notary public has satisfactory evidence that a person is the person whose true signature is on a document if that person is personally known to the notary. personally known to the notary. So no one can tell you, show them the law right here. I promise you this is good information. People perish by the lack of knowledge, right? Know your stuff so that no one can tell you what you can and cannot do as a notary. Let's continue. Where are we at? Okay. Number 2 is identified upon the oath or affirmation as a credible witness personally known to the notary. Hi. Okay, you gotta be quiet, okay? Is identified on the basis of identification documents. Until July 1st, 2013, identification documents are documents that are valid at the time of the Notarial Act, issued by the state or federal government agency and bearing a photographic image of the individual's face and signature of the individual. Section 6-103, Certificate of Notarial Acts. A notarial act must be evidenced by a certificate signed and dated by the notary public. The certificate must include identification of the jurisdiction in which the notarial act is performed and the official seal of office. B, a certificate of a notarial act is sufficient if it meets the requirements of subsection A and it 1 is in the short form set forth in section 6-105. 2 is in a form otherwise prescribed by the law or the state, or 3 sets forth the actions of the notary public, and those are sufficient to meet the requirements of the designated notarial act. 6-104, ending on page 14, acts prohibited. So we're going into what we cannot do as notary publics. A notary public shall not use any other name or initial in signing certificates other than that by which the notary is commissioned. So if you're going by your ex-married name and you've legally changed your name, you are no longer that person. So you need to go by the name that you are commissioned by, or you need to, as it said, change your name. B, a notary public shall not acknowledge any instrument in which the notary's name appears as a party to the transaction. So if you're refinancing and you're closing on your own refinance, like we say in the Army, that's a no-go. You can't do that. So if you are within a power of attorney, you can't notarize your own power of attorney, your own trust. Okay, just don't do it. A notary public shall not affix his signature to a blank form or affidavit or certificate of acknowledgement and deliver that form to another person with intent that it should be used as an affidavit or acknowledgement. D, a notary public shall not take the acknowledgement of or administer an oath to a person whom the notary actually knows to have been adjudged mentally ill by a court of competent jurisdiction or who has not been restored to mental health as a matter of record. So if you know a person is mentally ill, you cannot perform a notarial act in which their name is in the instrument. E, a notary public shall not take an acknowledgement of any person who is blind until the notary has read the instrument to such person. That's good information. F, a notary public shall not take the acknowledgement of any person who does not speak or understand the English language unless the nature and effect of the instrument to be notarized is translated into a language which the person does understand. So I want to just go over this. If you are notarizing a document in English and a person signing the document speaks a different language and does not speak English, you can still notarize that document if a person has a translator next to them. G, a notary public shall not change anything in a written instrument after it has been signed by anyone. That is self-explanatory, but let me give you an example. A few weeks ago, I did an apostille, and the client came back to me and asked me to stamp on the apostille or do something to a completed document already completed. I said, no, that's not legal for any notary to do that. I cannot go back and take a complete document that's already been finalized and edited in any way. I cannot add or take away from that instrument whatsoever. And we as notaries can't even seal any document that is required to have an apostille anyway. That is the purpose of the Secretary of State. That's the sole purpose of an apostille. H, no notary public shall be authorized to prepare any legal instrument or fill in the blanks of an instrument other than a notary certificate. However, let me just stop there and pause. I have been asked, oh, can you help me with my power of attorney? No, I'm sorry, I cannot generate legal documents. You cannot generate legal documents. You cannot help anyone with their will. You can't do that. You're not an attorney. That is illegal for a notary public. Let's continue. However, this prohibition shall not prohibit an attorney who is also a notary public. Remember, I talked about that in my last video in episode 2. Unless you are a notary public and an attorney, you cannot give legal advice. And according to here, you cannot generate a legal document. Let's continue. From performing notarial acts or any document prepared by that attorney. So if you are already an attorney and you so happen to become a notary public, you can do this. If a notary public accepts or receives any money from anyone in whom an oath has been administered or on behalf of whom an acknowledgement has been taken for the purpose of transmitting or forwarding such money to another and willfully fails to transmit or forward such money promptly, the notary is personally liable for any loss sustained because of such failure. The person or persons damaged by such failure may bring an action to recover damages together with interest and reasonable attorney fees such as notary public or his bondsman. Section 6-105, short forms. The following short form certificates of notarial acts are sufficient for the purpose indicated. Let me just pause here and just say, before we go into this, each form that you're going to see within this handbook is literally what the Illinois forms are supposed to be. So there is no PDF other than an all-purpose acknowledgement, but there is no specific forms like, where are our forms? Where do we get them? You don't have to pay for them. They're right here. So you would literally copy and paste what's here into a Word document, and there is your document. Let's continue. For an acknowledgement in an individual capacity, keywords. So when you're giving an individual, just an acknowledgement, this is what it's going to look like. Ending page 15. Let's go on to 16. B, for acknowledgement in a representative capacity. Say if you're doing a notary presentment, for example, you would use this instrument. For a verification upon oath or affirmation, you would copy and paste this whole section in a Word document, and that is your form. That is your oath. I have done this, and I have several of these documents in my briefcase. As I showed you, I will put a link card on the screen. So if you want to go back and look at everything I carry, all of my gear in my notary bag, you can. These forms, I carry all these forms. D, for witnessing or attesting a signature, you can fill right here, copy and paste. Okay, so we are actually going to stop here. It's already about 25 minutes into the video. And we are going to continue next week. We will go into what we are not allowed to do as notaries. Very good information. Thank you so much for watching. Don't forget to like and share this, and see you next week.